the Supreme Court just issued a decision on affirmative action quite recently. What does this mean for college admissions, and what were the specifics of the process of this decision, and why did it take so long? And also, why is this decision so important?
Yeah, so here's what I'll say about that. Here's some things that are clear from what the Supreme Court had to say today. The programs for admissions run by Harvard and the University of North Carolina are not constitutional and not okay. That's the first thing that's clear. It's a little less clear, but I think is also clear. The programs run by UNC and Harvard would have been okay under pre-existing law, notably the Grutter case from 2003. So we know those things. One other thing that I know, having been chair of the admissions committee here and just knowing about American law schools and American universities, is a lot of schools run an admissions program similar to UNC or Harvard. And by a lot, I mean most. Like, so what do we know after today? Most admissions programs at American universities, as currently designed, are no longer constitutional and will need to be redesigned. So those are all the things that we know. And I don't want to soft sell that at all. That's a big deal. It's a significant change in how universities operate, and it's going to be a big change going forward from here. Now, if you don't like the current version of affirmative action, then I guess you'll be cheered by that. If you think the current version of affirmative action is doing okay and or could do a lot more, then you're going to be quite disappointed by that. The court had the opportunity to fully overrule Grutter and Bakke and their old cases. And the court could have said universities, public, private, period, may never take race into account, period. And the Supreme Court, in my opinion, very pointedly did not say that. In fact, there's two things that they say that lead you to believe that race can at least be a factor in individual decisions in terms of admission. They have this whole part at the end where Roberts says, if a student wants to write an essay about how they've suffered from racial discrimination and how they've grown from that, they're allowed to do that. And the university is allowed to read that. And the university is allowed to say, well, that seems like a good reason to let this person into the university. And so you're like, hey, doesn't that sound like they're taking race into account? I think the answer to that, fairly stated, is yes. And so there's going to be this fine distinction between an individualized reading of each application and a student's discussion of what their life is like, which may or may not include racial information, versus the way that the Supreme Court stated it, and honestly, the way Harvard and UNC kind of ran it, where race alone was a factor that they considered, and race alone mattered in terms of the overall balance of the class. Considering race as part of the overall balance of the class or as a basis of trying to have generalized diversity based on race is now unconstitutional and won't be done. Considering race as part of each individual's journey getting into the university, that's allowed as of this opinion. That's the first thing. Second thing is super interesting footnote about the service academies, where they say the Naval Academy and the Air Force Academy and West Point are not involved in this case. And they may actually have different reasons for doing this that may matter more. I thought that was super telling and interesting. Again, we have no idea. Maybe they'll decide that those places also can't take race into account. But even leaving the door open for that is a significant crack in the armor in terms of what we thought, or what I thought we were going to get from the court.
Before I send the mic over to my colleagues, I have one more question for you, and it might be a little silly, but so just to clarify, when it comes to the application or applicability of this action into each individual school, we won't likely see any changes until the following term or the next admission cycle, sort of say?
Yeah, I'm pretty sure just as a matter of the timing of it, I think that's right. Speaking for this university, this law school, and every law school in America and every university in America, what's happening right like today, they're like, okay, pull the plug. We're going to have to rethink how we do this, and it'll take a little bit of time for them to rethink it, and then they'll come back online. It's actually it's sort of a good time for that. Admissions usually doesn't kind of goes to sleep during the summer anyways. But that being said, there's all these like letting people off the waiting list, all of that stuff. All of those decisions are going to have to be made in compliance with the new law.
Part of my question is anything going to change because of SCOTUS's decision on the applicant's side? Say they were going to go fill out the common application. Is the common application going to change? Was there a race box that won't be there now? Or did the applicant have to give some sort of information about their race that they will no longer be able to give in that sort of a setting?
Oh, that's a fantastic question that I can't answer. That's beyond my, like, seriously, I haven't applied to college in a long time. My daughters did, but I can't remember. So I don't know the answer to that. Insofar as the Common App had a, please tell us your race, that's gone. They probably can't ask that anymore. Now I know from my daughters, and I know here at the law school, there are a bunch of schools that have optional essays or mandatory essays that are like, tell us about a challenge you faced, tell us about something in your life that you had overcome. That's not unconstitutional. They're allowed to ask that, and the students are allowed to answer that question on the basis of race, and then the school's allowed to admit them. It's not right to say on the basis of race, but they're allowed to admit them on the basis of that essay.
You talked about the Roberts paragraph about the essay. And one thing that I got hung up on when I read that was that he talks about when he's saying, like, yes, the student can write about how race has impacted their life. He mentions something about, well, you still can't indirectly do affirmative action using this. Could you tell me a little bit about what that means practically?
That is a very open question practically. Okay, so there's a very controversial and still somewhat unevenly applied doctrine that they call disparate impact. And so under disparate impact, one way to talk about discrimination is to just come in and be like, I'm a state employee, I work at the DMV, my boss is a racist, and he calls me racial epithets all day. And that's an individualized basis of it. There's another theory that gained popularity in the 70s, and the Supreme Court has kind of pulled back on, that they call disparate impact, where instead of saying there's an individual who's been treated in a racist fashion at the DMV, they're like, it's a little weird. 100% of the employees at the DMV are white, and 15% of the citizens of the state of Tennessee are African American. Why would that be if it's not racism? I don't know that the Supreme Court's going to resuscitate that, and it would be especially weird here because it would be disparate impact for white people, which has never been done and is super squirrely. But there's a version of this where 5 years from now, in the opinion, you may recall, there's that chart where they have Harvard's numbers just right down there, and Roberts just crushes them. He's like, dude, the numbers are the same every year. Like, they're obviously aiming for numbers. And the people who are at Harvard are pretty smart, so presumably they'll make the numbers bounce up and down a little bit more. But I mean, if the same thing happened, if in 5 years the numbers are all the same, believe me, the people who brought this lawsuit are not done. They'll be back, and they would come back and they would be like, listen, I don't care how well you're reading these essays. Why are the numbers the same? The numbers should be different. And then the Supreme Court, and first the lower courts, but then the Supreme Court would have to decide whether they want to allow you to argue this just on the basis of the numbers, which would be weird. That would be hard. Like, that would be a disparate impact theory, and that would be a strange way for them to do it. All of that being said, I'm with you, man. How are they going to measure this if they're not going to do it based on the numbers? None of these cases have ever, or let me restate that. Bakke, Angruder, and this case, none of these cases come up as individualized racism cases. There are individualized racism cases, including at the University of Tennessee and every other Southern school, right? Where it was like in 1958, an African-American applied and they were like, oh, we're not gonna let you in, you personally, because of your personal race. That just doesn't, like, that's not gonna happen. There's not gonna be a white person who applies to Harvard where Harvard writes them a letter that's like, super sorry, you appear to be white. Like, they're not gonna get that. So then in terms of bringing the cases and proving the cases, they're going to have to do what they do here, where they work around the around the margins. And you're completely right. If it just so happens that Harvard reads the essays, and it just so happens that the percentages are all the same, that's going to be a challenge for courts to try and figure out what to do about that.
So just to be clear, this is one of the many things that are not.
Oh, totally. This
really
is very
all.
up in the air. It
Okay.
There's a version of this where every school in America has a meeting, and they're like, "Hey, remember when we used to consider race as part of balance or diversity?" And they're like, "Yeah, we remember that. That was yesterday." They're like, well, "Okay, so we don't do that anymore." And they're like, "Okay, that sounds good. We're out on doing that." Do you remember how we asked, or now we will ask, essay question that says, if you face a challenge in your life that you can talk about before you come to school, and if those essays include race, then we're just going to let those people in, and it's going to just so happen to work out to be similar to the way it used to work out in the past, based on our new individualized way of doing it. That's going to be a significant challenge for the court.
Does this shift from a checkbox situation to a, now I'm going to write you 5 paragraphs about my race instead of just checking a box, and will it come back to bite me later? And I think that the question, and I've not seen this question being asked yet, but I imagine it will be, if I am going to apply as a Puerto Rican woman to college next year, and before today, my essay was going to be about tomatoes. Right. And now I'm going to choose to make my essay all about myself being Puerto Rican. Is that going to be a benefit to me or a detriment to me under this new system?
So the answer to that is it depends. That's a classic law school answer. I will speculate, which again is I'm happy to do because I'm a law professor. I will speculate that that higher ed if higher ed wanted to, basically higher ed considers diversity to be an important thing. And now I'll use the equivalent of an I statement. I mean, the University of Tennessee, we're the flagship state university. We're supported by Tennessee taxpayers. Should the law school look like the state? Yes, the law school should look like the state. If the law school is not going to look like the state, is that okay? No, that's not okay. And so, do we have to if we have to read essays more carefully, wherever we have to do to have that reflected? I think that a lot of places will operate in that regard. So there, then you're like, oh well, maybe writing those essays would help you. Insofar as there are schools that are going to be like, no, really, we actually mean it. We're going to do a more individualized thing, and so this is a really boring essay. It's just like, hey, I'm Puerto Rican. Not that you would write one. I'm not saying that at all. But I mean, if the essay is really ham-handed in the way that it presents the thing. And just to be frank, you can imagine someone who's anyhow, there are ways that it could be ham-handed. I'll just leave it at that. I'm not going to get into it. Maybe that would harm people. Maybe people will change. Maybe the most significant challenge that they had is that their parents are disabled, or maybe the most significant challenge that they've had is poverty, or maybe the most significant challenge that they've had is that they personally broke their leg and haven't been able to walk, or whatever. You know what I mean? Insofar as it narrows down the choices and also forces people into boxes, then maybe that is worse. I don't know the answer to that.
I was reading, I think, a NBC News article where someone in the article mentions something like, some schools might react to this decision by forbidding students from mentioning race in essays or their applications, so that way no one can accuse them of using race in their applications. Are schools allowed to do that?
Yes. Well, I think it depends what you mean by allowed. The students, well, especially at a state institution, students will have a First Amendment right to write wherever they want. If you give them an essay prompt and you're like, but please don't talk about X, that would be a little bit weird, right? So I don't think that, especially a state school, would not be allowed to do that. That being said, schools are allowed to take it into account. So, for example, the University of Tennessee, as far as I know, is not like, please don't write racist essays, please don't write pro-Nazi essays, right? They don't say that. If they did say that, that actually might be a First Amendment violation, because the students might have a First Amendment right to write whatever crazy stuff that they would like to write. That being said, the university is allowed to read the essay and be like, whoa, not for us. That would not be good at all. By comparison, the university could theoretically be like, hey, please don't mention your race to us. We just don't take race into account at all, so we don't even want to know. That would be a little bit weird. And I feel like this student would be like, no, I have every right to tell you about my race. You can't stop me from doing that. That doesn't mean that the school couldn't hold it against them in this individualized analysis. Did that make sense?
Yes, thank you.
I don't
I'm
think
gonna
very many
ask-
schools. I don't think any schools are going to do that, though. That's the thing that's interesting about the opinion. The opinion did like. There's a version of the opinion where it's like higher ed will never and can never, from today forward, take race into account. And so don't ask about it. Don't consider it. Like just erase it from your brain. Even under that version of the ruling, I don't think that they could tell applicants don't ever mention your race. You know what I mean? Like for the reasons that I said. But that being said, they couldn't take it into account, even as an individual struggle type thing. So the fact that the opinion says you're allowed to take it into account does mean that it still will be.
The first question I had is kind of just more of a top level question. I know that this decision is specifically focused on race-based admissions and affirmative action. Are there other types of affirmative action in college admissions, whether they're based on gender or disability or other factors?
Short answer to that is yes. Gender is less universally done now because actually more women go to college than men. And gender is also held to a slightly lower constitutional standard than race. There is also consideration of religion. So you can consider like religion will sometimes be asked about and contemplated inside there. And that would be at the same level as race. So that would be controversial, not 100% clear you'd be allowed to do that. Although again, you would be allowed to do it in terms of the individual essay, but not in terms of trying to hit a particular religious number. But also poverty is something that people take into account, and that is generally allowed. And like being a veteran, like lots of schools take that into account. That's basically allowed. Being an alumni, being like a legacy is also allowed. And those are all allowed at this much lower constitutional standard because they're not about race or religion or gender.
Yeah, you mentioned legacy admissions, and that's actually the story I'm working on. So does the Supreme Court decision still allows legacy admissions, right? I think there's been a lot of discourse online about that.
Yes. It doesn't mention it at all, but short answer to that is it doesn't mention that at all. And the reason it doesn't mention that at all is because legacy admissions are going to be fine. Those may statistically result in racial bias. You can figure out which one it is. But that is not based on race. And so that would be fine. And it's the same thing with poverty. You're allowed to take first generation students or poverty into account. And I think I don't know that schools have. Oh, actually, I do know this. Texas actually did this. Like you could actually run a affirmative action system where you're like 10% of the class must be people who grew up below the poverty line or first generation students, and I'm pretty sure that would be constitutional.
That's really interesting. And I should have asked this earlier when I kind of asked you the bigger picture question, but could you kind of generally define from a legal standpoint give a definition for affirmative action as a whole and what it means?
Oh, I love that. So the first thing I'll say about that is, weirdly, it is a term of art, but it does not have a single technical definition. It operates differently. Like, so some of the cases are about like city set-asides for minority-owned businesses, and that's different than university that takes race into account. The classic version of affirmative action at a university level, and the one that hasn't been constitutional for a long time, is just the straight up 10% of the class will be African American and 15% of the, and I'm giving raw, like the numbers are made up, but like where you're like, there's what they would call a quota, meaning like we're going to have 10,000 students and 1,000 of them were African American, 1,000 were Latino, and the maximum number of Asian students we're going to, like the numbers are going to be, and then 1,000 Asian students and then 7,000 white students. That hasn't been legal for a long time. If that's what you mean by affirmative action, then that hasn't been allowed for a long time. If what you mean, so that's one version of it. That's the old. That's, in my opinion, the surveys that show that Americans don't support affirmative action, they don't support that. The more modern post-Grutter version of it is you're allowed to take race into account as one of a number of diversity factors. And so you're not allowed to target a specific number, you're not allowed to target a specific percent, but you are allowed to consider it as you go forward in creating a diverse class. And so then you're like, well, that it does sound different. But that's the more, if so you could say affirmative action just ceased to exist at the university level when they stopped allowing quotas. Or you could say, no, that's not really right, because if you consider it as part of this diversity rationale, and in fact it does result in more of certain groups getting in than not more, different overall criteria for certain groups and other groups, you could consider that to be affirmative action too. And that's what I mean by there's no strict definition.
Is there anything that we didn't ask you that you think it's important for our audiences to know or to understand, especially with big talker and big news worthy events like this?
It's going to take some time, and we're going to need to hear from lower courts, and we're going to need to hear from universities, and then we're also going to need to hear from the people who bring these lawsuits. Like, there's going to be a combination of all of these different things moving forward, and we don't know exactly what's going to happen here.